Okay, thank you very much, everybody. Start the late morning session. I think our first submitter is Kiwi Rail Holdings Limited, who are remotely connected to us. Can I just welcome you to our hearing? Can you hear and see us?
Thank you, sir. Yes, we can hear you very well and can see you as well. So kia ora and good morning. And first of all, thank you for accommodating us virtually. We really do appreciate it. KiwiRail is based all over the country and also has infrastructure all over the country. So it's greatly appreciated when we are able to have virtual attendance with you. My name's Kristen Gunnell and I'm external legal counsel for KiwiRail. I am here with Matthew Pates, who's a senior RMA advisor at KiwiRail and also has a planning background, and Ms. Catherine Hebblethwaite, who is an external planner providing assistance to KiwiRail on the Far North District Plan process. My legal submissions were circulated on Friday. They were pretty short, and I guess KiwiRail's appearing before you in relation to one issue, that of setbacks, and a few minor policy matters that Ms. Hebblethwaite can talk to you about that relate to that setback structure. I didn't propose to read my legal submissions, and I guess just by way of summary, I think it's setting up the framework for Mr. Pates and Ms. Hebblethwaite's presentation. But essentially, KiwiRail is generally aligned with the reporting planner on setbacks. Ms. Hebblethwaite has looked at the rural zone provisions and the sort of local conditions in the far north, and has proposed a tiered approach so that the 3 metres that I understand the reporting planner had accepted as being sufficient for setback from the rail corridor in the far north area. Ms. Hebblethwaite is accepting for shorter buildings, but for those higher buildings, we're seeking a 4 metre setback just to really make sure that there is appropriate distance in between a structure and the rail corridor. And I guess just the only other thing I wanted to underline was in this case we're talking about rural zones with very substantial areas and land holdings, and I guess from KiwiRail's perspective we would really hope that there wouldn't be any buildings or structures that would come close to that rail corridor. So that was all I proposed to speak to just by way of introductory remarks, and I was going to then hand over to Mr. Pates to talk you through KiwiRail's operations in the Far North District, and then Ms. Hebblethwaite to talk you through that proposed approach to the setback provisions. I'm happy to take any questions now or at the end once you've heard from Mr. Pates and Ms. Hebblethwaite.
I think we're quite happy to hear both witnesses, and then we'll answer some questions at the end. It may be that some of our questions may be best addressed by Mr. Pates or Ms. Hebblethwaite, and so we'll allow who's the best one to answer. It may be yourself.
Thank you, sir. So I'll now hand over to Mr. Pates.
Good morning, everyone.
Morning.
Morning. Thanks again, as Kristen said, for taking us remotely with this wonderful technology we have. So I just propose to I guess, talk to a few key summary points from my evidence. As Ms. Gunnell said, I'm a qualified and professional planner, but I'm appearing in my capacity today as a corporate witness for KiwiRail. So just in terms of a summary, I'm a senior RMA advisor at KiwiRail. I just would like to briefly highlight the importance of rail in the Far North District. I provided a summary of KiwiRail's activities in the district in hearing stream 6, but given that there is a change in panel members, I propose to summarise this briefly again. My evidence sets out that the rail network is a nationally and regionally significant infrastructure asset, which needs to be provided for and protected through appropriate planning controls. I won't repeat the detail from my evidence statement, but I did want to underline the benefits of rail, including that rail produces at least 70% less carbon emissions per tonne of freight carried compared to heavy road freight. Importantly, KiwiRail expects that demand for rail freight and passenger services will continue to grow across the country. And as an example of the continued commitment to rail, the government has recently announced over $100 million in investment for metro rail networks in the Auckland and Wellington centres. It's obviously not the far north, but that's just to demonstrate the ongoing commitment to rail, more broadly speaking. However, in terms of Northland, the government has also invested in the recovery of the lines in the region after the 2023 weather events, which created a significant amount of damage to the railway network. And as a local example of works being undertaken in the district, I'm actually currently working on a consent application for flood mitigation works at KiwiRail's yard in Otiria in the district. These works are occurring around our rail corridor and complement the broader works in the area being undertaken by the regional council. So as the panel will be aware, the key railway line in the far north district is the North Auckland line. This line is not currently operational in the district, but is a valuable infrastructure asset. KiwiRail's designation means it could become operational quickly at any time in the minimum 10-year life of the proposed plan, if there was demand or need. And just on that point, things can and do change quite quickly in the world of railway operations. And I just thought I'd mention, we are working on the Marsden Point Railway Link excuse me, project, early stages of preparing an alteration to designation in the railway link, the spur that goes out to the Marsden Point port. That is one of the projects listed in the fast track bill. And if that project does go ahead in the short to medium term, then it's quite likely that we'll see the North Auckland line opened again. At the moment, we're only running between Kauri, just to the northern part of Whangarei, and the port. But it's quite plausible that we could see operations back in Far North District in just a few years' time. Just in terms of the setbacks, setbacks provide a physical distance, obviously, between development and the rail corridor boundary. Just to be clear, the primary purpose of the setback is as a safety buffer rather than to mitigate against rail noise and vibration. The rail corridor has a very different and high consequence risk profile compared to entering other sites, for example, adjoining rural properties. And people entering the rail corridor are at significant risk to their own safety. KiwiRail appreciates that these safety risks were acknowledged by the council officer. So without an adequate setback distance, landowners who need to use and access their buildings for maintenance or to carry out other activities on their properties would need to ask KiwiRail for permission to access the rail corridor, or if they do not ask permission, trespass onto the rail corridor and run the risk of being hit by a train. A permit to access regime is very disruptive to the rail network as it requires on-site safety personnel or temporarily closing a part of the track. So the better outcome is to provide an adequate setback within a landowner's own property to allow sufficient space for maintenance. Ms. Hepplethwaite's planning evidence, sets out the planning basis for why the setback should apply to 4 metres for taller buildings. That is, buildings that are 4 metres or taller in height, and a 3 metre setback for less tall buildings up to 4 metres in height in the rural zones. KiwiRail accepts this tiered approach as a pragmatic option in the far north. Just in conclusion, I consider it is appropriate and necessary to include setback controls in the proposed plan to protect rail operations from interference and to ensure the safety of communities located near the rail network, if and when the North Auckland line becomes operational. That was all I proposed to talk to today, and I'm happy to answer any questions from the panel.
Yeah, maybe one just of a more general nature. You talk about the potential link up to Marston Point, which I know a little bit about, so as Mr. Van Broadhouse's memory. What's the reality of that? Is that something you're saying that there's some optimism about that, and say for the next 5 years?
Thank you for the question. It's very hard to say. The whims of government funding on infrastructure projects at the moment. I guess all I can say is that we're advancing our planning and preliminary design for the corridor or the link to the port, and we're in the early stages of the RMA planning work that will be necessary for the required alteration to designation. So yeah, I'm sorry to be imprecise, but it is very much subject to funding and financing priorities. But I would say it's definitely a realistic possibility for that to proceed and potentially be operational within 6 to 7 years. But yes, as I say, very hard to be any more definite than that.
Thanks for that. It's a fairly general question anyway, so thanks for the information.
You're welcome.
Okay, I've got a question, but I think I'll wait till we hear Ms. Hepplethwaite's evidence because it may be she's better to answer it. So we should move on to her. Good morning, Ms. Hepplethwaite. We can see you, and I think you are unmuted.
Atamario panel and council staff, thank you for hearing us remotely. It is most useful, as Mr. Pates and Ms. Gannell have said. For those of you I haven't met, I'm Kath Hepplethwaite. I'm a planning consultant and I am assisting KiwiRail with this assessment. As Ms. Gannell has foreshadowed, I propose to be relatively brief today. And I thought perhaps the most helpful thing I could do would be to lead the panel to my attachment A, which is at the back of my statement, and perhaps just walk you through the proposed amendments and to acknowledge Ms. Pearson, her report, and that I largely agree with it except for the remaining items in attachment A. If it is helpful, it's PDF page 11 in my evidence. I cannot tell. I trust you have found that.
Thank you.
Excellent. So what you'll see there is effectively 3 groups of amendments. The first one relates to policies, which is on page 11. The second group relates to standard, which commences on page 12. And the third group relates to matters of discretion, which is also on the bottom of page 12. They're grouped together because the changes to the rural production, rural residential, rural lifestyle and rural settlement zone policies are largely the same. They look to include reference to the rail designation boundary for zone interfaces. That provides a policy framework for the amendments around building setback. The next change is to standard 3 in the same zones, and those amendments again are slightly different between the different zones, reflecting the different structure of the rules, and they reflect a tiered approach to setbacks depending on the height of the building and its proximity to the rail. The thinking behind that is to recognise that there is a height to boundary control in these zones that's set out in the table earlier in my actual evidence, and there are variable building heights allowed in each of the 4 zones. The last amendment is on the top of page 13 in the PDF, and that is simply to include a matter of discretion for the 4 zones I described, the 4 rural zones, which considers the outcome of any consultation with KiwiRail. The purpose of that is to enable the landowner and council to be aware of and consider what KiwiRail might be planning or not planning in the zone, and for that to feed into the consenting process to determine whether a reduction in the setback is indeed appropriate. That was where I thought I would leave that, and I'm more than happy to answer any questions about the remainder of my evidence or the changes proposed. Sorry, and one other thing, I'm unsure if Ms. Pearson addressed this, my proposed changes in her opening statement, but I would be more than happy to have some direct discussions with her if that assisted the panel in any way.
Thank you, Ms. Eccleswade. You've attached a number of other documents to your evidence. I'm just wondering if you could just briefly take us through what they are and what their significance are to this matter.
Most certainly. So I'll start with attachment B, which is a section 32 analysis. During the, some of you will be aware that KiwiRail has been attending a large number of hearings across the country for various intensification plan changes. And during that process, it became apparent that more work was required to consider setbacks. And in that regard, I was asked to complete a section 32 assessment. That is attached as attachment B. Supporting that section 32 assessment are 4 other attachments. The first one is a recommended suite of provisions, which I concluded were appropriate at the end of the section 32. That is based on attachments 2 and attachments 3 through the section 32. One of those is a technical assessment by Anna Galvin, who's a principal at Galvin Consulting. Her expertise is in health and safety, building maintenance and setbacks, and she's provided a fairly detailed suite of advice in that regard. And the attachment 3 is Insight Economics, which provides a high-level assessment of impact on particularly housing supply as a result of providing the building setbacks. Attachment 4 to the section 32 is a broader commentary on things which are perhaps a little bit outside of the scope for standard section 32 analysis, but they do address what we found were commonly occurring questions resulting at hearings. So that's included. I included that for information and background for people addressing and considering setbacks. So that's attachment B. And if we just scroll down further, sorry, past Anna's report. Please excuse me, I'm on screen scrolling today. Right, attachment D is a joint witness statement. As I mentioned, I have been assisting KiwiRail in a number of jurisdictions. The issue of setbacks and building heights and height to boundary interface has come up in other jurisdictions. And my attachment D is a joint witness statement with myself and the Council's consultant planner for the combined Wairarapa plan. This issue of setback distance and different building heights was addressed specifically during the joint witness conferencing that I had, and I thought it was useful to provide the panel with an example of the agreed position that the council planner and I came up with in what, in my opinion, is a fairly similar situation. And I think that actually concludes my attachments, although, yes, does that answer your question, Sue?
Yes, thank you. I'll just see if some of the other panel members have some questions first.
Yeah, hi, Kath. A long time since I've seen you, but just in terms of the work you do around the country for KiwiRail, I was just interested in that matter of discretion about the outcome of consultation with KiwiRail. I mean, is that the sort of norm that you're seeing emerge in those matters of discretion? It seems very subjective sort of matter to be included like such.
I think it's important to have the matter of discretion there so it enables the close relationship of the boundary setback and its purpose to be considered, because the use of the rail line is quite variable Mr. Pates has described to you what may or may not be happening in Northland, and that's quite different to perhaps what is happening in Wellington. So identifying QRL as an affected party is potentially not an appropriate pathway to take, but allowing the council and applicants allowing the council and signalling to applicants that some discussion with QRL would be advantageous, I thought was an appropriate matter of discretion.
Okay, thanks. Yeah, hi Keith, it's Peter, Commissioner Kensington here. Nice to see you as well. Long time no see. I have two questions, and one is specific in relation to the rural lifestyle zone changes that you're recommending in your Appendix A to the standard 3. I couldn't correlate that with the Section 42A version of the standard that I've got in front of me. There seemed to be a different set of wording there, and maybe staff can assist in that regard, or maybe you can help me as well. The wording was quite different.
Right. Could I suggest that we could clarify that for you? It might be that I have made a copy and paste error. I'm not sure, but perhaps we could clarify that for you with just a brief written statement following the hearing, rather than me digging through the report and trying to provide you perhaps an accurate on-the-spot answer.
Okay, thank you. It's just to clarify, it's the rural lifestyle zone standard 3.
Thank you, sir. I've made a note of that.
Yeah. And then the second question was really, a lot of the information that you've given us, including from Mr. Pates, it's across the country, and some of it, and including your joint witness statements for a residential zone, whereas we're looking at rural zones of a line that's not operational, which might be in the future, quite wide designation boundaries by the look of it on the mapping, single line that's going through there. Is the issue that we're trying to address real here, or is it kind of a little bit less relevant in the far north, in the situation where we're rural, and what's the problem, or is it a future problem that we're trying to compensate for here?
Yeah, it's an excellent question, and I did think carefully about including the Wairarapa JWS because it is a residential zone, but the residential zones had a very, very similar and closely matching height to boundary and maximum height, particularly if I can refer you back in my evidence to page 6, which has got table 1 on it. So this is the far north provisions. If you look at the rural lifestyle, rural residential and settlement zones, they're all 8 metre height limits, and they've all got 2 metre, 35, 45 or 55 degree height to boundary provisions. There is some variation in lifestyle depending on site size, but the others are quite standard. Now, most of you will probably be experienced enough to recall that an 8 metre height limit is extremely common across residential zones, and those height to boundary controls are also extremely common across residential zones, notwithstanding the MDRS provisions that are in or coming in, but the general provisions you can see there, particularly in the lifestyle, residential and settlement zones, are very similar to residential. I think it's also, I'm mindful of Ms. Ganell's comments that in the rural zone there are often, not always, but often more choice or different locations for buildings to be located away from rail outside of the height to boundary and yard requirements. So sometimes there's more flexibility just because of lot size. And the to answer your last, so yes, I do think that the residential is comparable insofar as the controls are similar. And for your last question about, is it a future problem or a now problem? It is possibly a future problem, but one which I could envisage could occur in the life of this plan of 10 or more years, where there is new development proposed on sites in the rural zones.
Okay, thank you for that. That's helpful.
Yeah, mine's probably a bit of a follow-on from Peter's question. That line, once it hits the far north around the Hokanui area, is pretty much rural. It runs through a lot of farmland and some wetlands. I think Matthew is probably well aware of the flooding issues that might be apparent. But the question I had related specifically to farm crossings. I know that those farmers that do where a total crosses a line, they have crossings which are licensed, I understand. But my question was, if someone was to wanting to do a subdivision of land broken by the rail, is there anything in that part of the plan that needs addressing?
The subdivision chapter, sir, is that your question? As in to do with new or existing rail crossings?
Well, the line currently runs through some big property. It's mostly quite large land areas. And if someone was to chop under our subdivision in that rural production, for instance, I think it's 40 hectares. If there was a new title to cross that, what would be the process or the requirements of Kiwi Rail in that instance?
I might defer that to Mr. Pates, as that is more of an operational management issue. Matthew, if you would be so kind.
Yes. Well, it's I guess any time that there's a subdivision, whether in a rural setting or an urban setting, where the proponent, I guess, of the subdivision or land use consent has a legal arrangement with Kiwi Rail, for example, a railway line crossing, then typically there'll be consultation required, and typically Kiwi Rail will need to kind of, I guess, reauthorize, if you like, the railway crossing that's in place. So I'm not sure if that answers the question, sir. But yes, yeah.
Okay, thanks. Just a couple of questions for you, Mr. Pates, while you're there, but equally, if anybody else wants to add, I'm quite happy. Can you give us some advice as to generally how wide your existing designations tend to be? Are they fairly uniform? Width?
So they do vary quite significantly. I mean, a typical width is sort of around the 20 meters, but they do actually vary quite a lot, depending on, I guess, context and historical decisions and so forth. They can. You do see some designations where they, wax and wane in terms of the width, and I guess related to a number of historical property type matters. So
20 meters be sort of like your standard minimum width of your designation? Does it get more constrained than that in some places, and in particular in this district?
I don't think it would get much more constrained than that. I think around that 20 meter width is fairly typical.
And for the actual rail infrastructure, is it generally sort of 5 meters within that? Just for one line? I suppose I know you have to have double lines in places and what have you, but just generally for one line. For one line,
yeah, that sort of sounds generally about right. I mean, you've got obviously the rail infrastructure itself, which I don't know is a meter to a meter and a half or so. You've got the ballast to the side of that. So yes, roughly about 5 meters, I guess, very roughly in terms of one single line. Of course, we'll often have other infrastructure structures or utility structures that relate to the railway operation. Yes, but in terms of the actual one single line, just for that particular infrastructure, that sounds about right.
Thank you. And this one's a fairly broad question. Can you let us know what is the biggest challenge to Kiwi Rail to getting the Northland line operational again? And it may not just be one.
Yes.
Or say physical and financial.
Yes, I would say it's less physical and it's more economic, broader economy QRAR is a state-owned enterprise, and we run as a commercial entity. So I think the key thing really is the demand to move freight by rail is I would say probably the biggest factor. Of course, too, is the infrastructure investment that may be required, but I would say for the North Auckland line and the Far North District, probably economic demand for the movement of freight by train is probably the biggest issue, I would say.
And so in terms of the actual physical assets, the lines, the bridges, what have you, are they all in reasonably good condition? Has there been some recent survey as to whether they're up to scratch, or does there need to be some physical upgrading if it were to become an operation?
I don't have detailed knowledge on that matter, sir, but I mean, generally speaking, I think the infrastructure is generally in place. I mean, I think one of the key issues was the storm, the cyclone, and there were areas of significant damage to the network, which I believe have been remediated now. So, yeah, my understanding is really it's the economic side of things. I mean, as I mentioned earlier as well, I think whether or not the railway branch to Marsden Point goes ahead would be quite a key factor, and whether the network in the Far North District is operational again. Having said that, there could be the scenario where there is a demand and need to use the line even without the link to Marsden Point.
Yes, I was going to say, is the key Marsden Point to get Far North operational? It doesn't need a link to Auckland, does it?
That's right. It's the key thing is to service the Northland region, but there's that broader connection to Auckland as well. Broader network matter and economic connection.
But in the first instance, would it be the connection to Marsden being that freight connection, or does it need to go hand in hand with the connection to Auckland?
Sorry, sir, what was that? Does it need to go hand in hand with the
connection to Auckland? In other words, is a connection to Marsden Point sufficient in the first instance? Obviously, because it connects to a commercial port. Or does it really need a connection to Auckland for it to be viable?
I'd probably defer on answering that question, sir. It's beyond my knowledge at this point.
Okay, no, that's fine. But just one last question, probably on this Hebblethwaite. You've come up with this rule which says the higher the building, the further the setback. And you've sort of referred to high relation to boundary. Obviously, that's a daylight sunlight control. Can you just take us through the rationale as to why the separation needs to be wider the taller the building gets?
So the diagram you'll see, sir, in...
Is that the diagram on page 12 of your reports?
Sorry, sir, just looking for that.
Or page 12, sorry, of your first attachment, sorry.
Yeah, so that might be the one. It's probably figure 1 in the section 32, I think. Hold on. Yes, that would be figure 1 in my section 32 report, which is on PDF page 26. It shows a series of building heights, it shows scaffolding, and it shows drop zones and people working around the scaffolding. If that's the one you're referring to, sir, that is from Ms. Galvin's report. And you'll see there that the height of scaffolding, and therefore what Ms. Galvin has advised me are things called outriggers, which are the angled piece of scaffolding. The taller the scaffolding, my understanding is, the wider the outrigger base needs to be for stability. So Ms. Galvin's diagrams, as she sets out in her report, provide for freestanding scaffold. they're not tied into buildings, so it enables a fairly commonly accessible form of scaffolding to be provided in there. So those below the actual diagrams are numeric setback. She's got a number of distances set out there, and it's based on those drawings that I have gone forth and ascertained height of building from boundary with the appropriate height to boundary controls. Now, I would just note that in my figure 1 there, which is Ms. Galvin's diagram, the height to boundary control shown there is 4 metres and 60 degrees. That is the MDRS height to boundary control. That is not a 2 metre, 35, 45, 55 degree control. So in that regard, the height to boundary control is not applicable to what we are dealing with today, but it does, the diagram does reflect the fact that the further away from the boundary you get, the less impact height to boundary has on building height, and the taller buildings can be.
Right. And so the taller the building, the more scaffolding width you normally require. Is that the general principle?
Very succinctly put,
Also,
sir. And at some point, obviously, scaffolding may cease to become a feasible option, but it is a commonly used form of access for, I will say, smaller scale buildings. And by that, I mean sort of, 3 to 4 stories or less.
And I suppose this is sort of like the drop zone, obviously, like thinking that items might bounce off the support structures and then bounce into the rail corridor.
Yes, sir, that's correct. The other thing, which is not perhaps quite so relevant for the rural zone, but definitely for residential, is if there are opening windows in the face of the building structure. And perhaps, you might bump something off your kitchen windowsill, which might then bounce into the adjoining corridor. But as I said, that's not quite so relevant for rural.
Yes. Okay, no, I think I understand the rationale. No, thank you. Okay, thank you very much. We have no questions either for you, Ms. White, or the other witnesses. No questions for you, Ms. Gunnell, when this specific nature.
Thank you, sir. And I guess just one additional point for me, just building on Kath's comments about Wairarapa, the joint witness statement related to the residential zones, and that tiered approach was agreed there. But just to confirm that for the rural zones, which were also the subject of the setback hearing, that the officers did accept the 5 metre distance sought by QRail there. We haven't had that decision report out yet, but the sort of understanding of Wairarapa is that this tiered approach is being applied to residential. But Kath, correct me if I'm wrong, but the 5 metres was accepted for the rural zones there. So that was the only point I wanted to add. But just thank you again for your time, and all the best for the remainder of the hearing.
Yes, thank you. I'm sure we'll see you at further hearings, possibly residential zones.
Yes, yeah, we do tend to pop up. Thank you, and Merry Christmas, because I don't think we will be seeing you before then. So gosh, we're already there.
Next hearing is in March next year, but it will come sooner than you think.
Yeah, absolutely.
Take care until then, and we'll see you again. Thank you.
Thank you. Cheers.
Thank you.
So now we're moving to submission 82, House Movers section of New Zealand Heavy Association Rules. Jonathan Barnett Thompson. Are you there, Mr. Thompson? There you are.
Good morning. Yeah.
Good morning. Okay. So you haven't submitted any evidence to us in writing, have you?
So there is. Yes, it came through on Friday. Yep.
So I'm just catching up with that. I'll get you to read through it. I think I haven't had the chance to read it just yet.
That's quite all right. Happy to avail you of the relevant points that we'd like to make. Yeah.
This is an expert evidence anyway, so you're entitled to read your entire piece of evidence to us if you want to, or you can give us a summary.
Listen, I think I'll give you a summary because I'll save you the trouble of reading it, hopefully. Yeah, but once again, thank you for the opportunity to present by video link. That's a very useful thing for us. And listen, I just want to check that you're hearing me okay. I'm getting a little bit of distortion at my end.
We're hearing you perfectly fine. Can you hear us okay?
Yep. No, that's all good. Yep. I'll just turn my speaker down a little bit. Okay. All right. So listen, my name's Jonathan. I'm the Chief Executive of the Heavy Haulage Association. We're a small transport-related association. Good to see transport, first rail and now us being represented first up at this hearing. And we represent the majority of house movers that relocate new and recycled houses onto new sites around New Zealand. And so we've been making submissions to district councils since we first started doing this in 1998, and we've been more comprehensive in doing that over the years. So perhaps I could point you to, on the very last page, there's this map that looks like this. Hopefully it's a coloured one. And so this just illustrates, I guess, where we've got to so far with our hearings since that time. And just to talk you through what it means is all the council areas that are illustrated in green, they're all got permitted activity status for relocated buildings. Some of them are some of them have no particular controls, and other ones have specific performance controls, which I'll get onto in a minute. The yellow ones are ones that are in process, so you'll see Far North there in yellow. But also just to talk to you through, so some of the other ones, it's been a busy year this year actually. So moving from from south to north, sorry, we've appeared at Gore, and they've got permitted activity status. The combined West Coast one, so that's got proposed for permitted activity status. Timaru is next year. Waimak is another one that has going to move to green, being permitted activity status. A couple of months ago, there was the combined Wairarapa one. They also will move to green, being permitted activity. Waitomo is another one that's in the same boat. I see a little yellow bit around Napier. They also have proposed permitted activity status. So I guess the picture that I'm trying to paint is really that most of New Zealand now has very similar controls for relocated buildings. There are some local, I guess, little tweaks or iterations or specific matters relating to those areas, but primarily they have an option for permitted activity status. And really that's what we'd like to see being achieved also for Far North. The problem that we have is that the proposed plan appears to be rather silent on what the status of relocated buildings is, aside from, I think, the Carrington and heritage areas. So this is quite unusual, really. It's as in the operative plan, I understand there is a specific permitted activity status for relocated buildings. And we did first engage with the draft plan for Far North in 2018, and then we've further engaged with this proposed plan. So I think we've tried to point out the kind of controls that should be achieved, and so that's what we'd like to try and achieve further in making this verbal submission to you today. Rural areas typically quite often see a lot of relocated buildings moved into the areas, whether it's for housing or I guess temporary housing. There's also utility buildings, barns, sheds, all those sorts of things that are quite often, it's easy to bring on the back of a truck than what it is to get one built on site. And so it's quite a useful technique to get a new building. And as I said, in rural areas, it's quite a positive, or can result in a positive outcome. So as a result, we believe that it's crucial that there are actually specific measures to make clear what the status of relocated buildings are. And at the present time, we don't think that's the case. So section 3 of my evidence there talks about where we're addressing the staff reports. And you'll note in point 3.2 that we disagree with the recommendation that a specific relocated building rule should not be included in rural zones. We believe that there needs to be. There's a bit of analysis there about what a new building onto a site means. And really what we'd like to point out is that we believe that the analysis in terms of what happens in the relocated building world is it's different from what is from what the analysis that was carried out there. So really a new building in our world means one that's constructed probably as a relocatable building in one of the factory sites, if you like, and then transported as a brand new building to a site. It doesn't mean a recycled building which has been at a site and is brought onto a new site and therefore it becomes a new building. That's not the terminology that's used in our industry, and therefore really that needs to be updated and reflected in what's written in the district plan so that it actually matches what happens in the real world. As I said, we're in favour of a specific reference to relocated buildings as we advocate for performance conditions. And really this is to ensure that the building is incorporated onto its new site in a timely manner. So the kind of things that we're after are actually in Schedule 1. Isn't it funny how we put all the important things in the schedules? Anyway, so Schedule 1 talks about the kind of drafting that's the second to last page, or page 11. Yep. And so you'll see there that this is what we propose, and so you can see that these are performance conditions that need to be attached, we believe, to permitted activity status, and these need to be written into the district plan. So part of the thing, so you'll see at performance condition 3, for example, we believe there should be a pre-inspection report, and this is for a second-hand building, so that when it arrives to site, there is a list of things that needs to be done to get that building up to standard, right? And that there is a timeline around that, and we've suggested a 12-month period, right? We've also in performance 4 suggested, condition 4, that the building should be on permanent foundations no less than 2 months after it's arrived to site, and really that's just to prevent that sort of situation arriving where a building arrives to site and it's not put on any permanent foundations. It needs to be on foundations within a reasonable time frame, and that's really what we see as, listen, that's I guess it's a condition that's worked successfully around the country. And then, as you said, yeah, basically the other reinstatement work. So whether it's reinstating guttering or baseboards, any of those sorts of things, just to make it look as a functioning building. So that's completed within that 12-month period. So in order to get those performance conditions in, then we need to have a stated condition or status, if you like, for relocated buildings, and we're concerned that the way that it's worded in the district plan at the moment, that it's silent, and in fact it could be seen as non-complying. And really we need to be encouraging relocated buildings by stating them as having a specific status there, and that's permitted activity status. You will see in the column on that Schedule 1, so stating that where, for example, for whatever reason that the building be relocated to a new site can't comply with those conditions, so like the 12-month period, for whatever reason, let's say the applicant wants 2 years, then that needs to be part of a restricted discretionary, and therefore that is up to the council planners to set some criteria around when that should be. So it's permitted activity status. If you can't comply with those performance conditions, then it should default back to restricted discretionary. And we believe that this needs to be stated in the plan. The way that the plan's worded at the moment is unclear as to what the rules are, and we believe that there is value in having those performance conditions stated in the plan. I guess the final point really is the value in having this in your plan is that there are very similar rules in other plans around New Zealand, and really that helps with house owners wanting to relocate their buildings, with architects knowing what the rules are, house movers knowing what the rules are, so that if there's a very similar understanding of rules nationwide, then that assists with compliance and easy understanding and getting affordable housing onto sites. That's really what we're after. So I think that's in a summary. We're what I want to point out to you. There's a bit more detail in the submission there, but happy to take any questions.
Great, thank you very much. Thank you for taking us through that evidence. I'll just cast around the panels.
Yeah, thanks for your presentation. One of the difficulties with the relocated buildings is the appearance of them, what they look like once they've been put on the site.
Yes.
Whether it's residential or environment or the like. I mean, the only answer that you're really giving us to that is that there has to be this building pre-inspection report that identifies the reinstatement works that have been completed to the exterior of the building. And that's to include certification by the property owner that the reinstatement works been completed within 12 months. Yeah, I guess I don't want to sound like a control freak, but it's just trying to ensure that actually happens. And, you know, I've got a particular case in point in another district where that just simply hasn't happened. But a difficulty trying to convince an owner that he has to do more than just put a house on the site and do nothing else. Now, do you have an answer to that at all? Is there some way we could make that perhaps more prescriptive and still maintain permitted activity status?
I think that pre-inspection report is the key really here. So basically what happens is at the same time as the building consent is submitted to the council, the report on the building is also submitted. And so basically that goes through and identifies the things that need to be done. So basically the house owner knows in advance and the council knows in advance what items need to be done. Now, it could simply be baseboards and, you know, steps up to the thing, or it could be a new roof, it could be painting, any of those sorts of things that need to be done. I think the key thing is the house owner knowing what those things are and then committing to that 12-month period.
Yes, so what you're saying is really those reinstatement works that are in the report, they would need to be included as part of the building consent application so that there was some surety that they were going to occur.
Yes, I mean the items are probably not needed for the consent as such, you know, like the items will be like the new foundations and the plumbing and things like that, right? But I guess what we're saying is that that report is submitted at the same time so that everybody understands and agrees what the work is that needs to be done.
Okay, thanks.
Yeah, I've just got one question. Thank you for your statement, Mr. Barnum Thompson. You were noticed in the officer's recommendation reports to us that they've included the words relocated buildings in the first rule of each of the zone visions. So it's kind of explicit in those rules. But what you're saying to us is that you want a bit more sort of detail into those rules specific to assist people promote relocatable buildings as a good place, I guess. And you've given us your Schedule 1 wording, which you want to put into the plan. My question is it just the New Plymouth and Central Hawke's Bay district plans at your paragraph 6.4 where that has gone into a district plan, or are there any others where that more specific wording has happened?
So I would say, and this is just an estimate, probably 50% of the councils around New Zealand have that or very similar wording.
Okay.
Yeah, that's very common. And I guess over a period of time, like we've submitted to councils, we've got their feedback. I think there might have been the odd word tweak somewhere along the way, just to, from feedback from the councils, but that's very common, the kind of things that we have there. Yeah.
So what you said out at your Schedule 1, that is in district plans throughout the country, 50% of the time, you're saying?
I would say that's my estimate. Yep.
Oh, that's helpful. Thank you.
With regards to Schedule 1 wording, is this something you've developed specifically for this planning instrument, or does this wording appear in other plans that you've shown on your
Yeah, no, it's common wording. It's a common wording that we submit, that we seek. That's correct. Yeah, yeah.
And I'm assuming you want it to apply to multiple zones, all the rural zones?
Sorry, just tell me that again. Just dropped out.
Want it to apply to all the rural zones?
Yes. I guess we're making a broad brush submission, and so I guess I'm just thinking there could be some of them that it may not be relevant to if housing is not permitted there in the first place, like as a new construction, then the same rules should apply to recycled buildings. Yeah.
Yeah. Okay. Thank you. I don't have any further questions.
Thank you.
While we have Mr. Barnum Thompson here, I'm just wondering whether the council officers would like to respond. You don't have to, but if you'd like to, or you think you can provide some sort of response, here's the opportunity.
I think I can provide some clarity in terms of our approach. Essentially, there's been taken the decision to treat relocated buildings in the same way we treat it. So, for example, has not been included as rule one, largely the rule ones, then the types of essentially, and that will cover new and relocated regardless of age. So the plan doesn't specify information requirements. That's linked to the particular provisions in the Building Act, for example, connections to wastewater treatments, etc. So essentially, what Mr. Barnum is proposing is actually additional regulation to what is in the plan. In fact, we sort of don't distinguish between new and relocated programs in the PEP. What is proposed is essentially additional requirements. And I would suggest, that my understanding is this is a conscious decision to be able to enable as many much research development as we can achieve without having particularly additional variation. Probably would have heard questions from Commissioner Floyd on other requirements around provision of housing in Auckland Fund, and this is one of the conscious decisions being more enabling, while respecting knowledge existing arguments that's coming from last speaking village, and like to retain the low regulatory threshold for impact at this point in time. That's not to say that the building team will have their own requirements about inspections, but we don't see this necessarily to the intention of PEP framework. That's an action.
Thank you. Mr. Barnum Thompson referred to a concern that they had that without the specific provision that might be interpreted as becoming a non-compliant activity. Could you give them any reassurance while we're here?
Absolutely. Look, and I think in his evidence refers to Mr. Genson's evidence that actually we heard here actually under chair on the same matter, essentially and putting that in. We felt that the intention of the plan was to do that, and providing the additional term rule. Relocated building that he was felt embraced as approach to being certain, providing additional certainty. We weren't actually of the opinion that actually was necessary, but it was helpful.
I might actually also add to that, it sounds like some of the uncertainty Mr. Barnum obviously raised today has come less from my recommended wording about one and more about the definitions that go along with that. And I didn't address the definitions in my 42 reports because they were significant points allocated to the interpretation hearing, which hasn't been heard yet. So the question about the 2-year window and, have we adequately captured, I guess, everything from a brand new building through the first 2 years and beyond, I think that comes more under the definitions question, but I guess my intention of including the words relocated building in the R1 rules of the rural zone is that it would capture right from anything from new building all the way through, and it's supposed to be enabling there. So the definitions will look at that, and maybe that's where we address some of the uncertainty that's been raised today, as opposed to tweaking the R1 rules or adding new rules.
Okay, thank you. I hope you heard some of that exchange, Mr. Barnett-Thompson, and it gives you some. Obviously, we'll still have regard to your submission and your relief, but I just thought it might have been helpful to you to hear council's further comment. I hope that's been of some assistance to you.
Yes, no, that was useful. It was a little bit indistinct, but I think I heard most of it. I think I'd just like to reinforce that there is a definition of relocated building in there, right? In your rules, and that's only referenced in one zone, right? So therefore, not referencing it in all the other zones leads to potential confusion.
Okay, I think you made your point loud and clear.
Okay.
I'll leave it there. Are you going to be involved in the interpretations here?
Yes, we would certainly, if we haven't resolved this, I mean, I think the next most relevant one for us will probably be the residential one, and I guess we'll be making the same sort of statements. And but I guess it's a bit of a chicken and the egg. Like if you sort out the definitions, then maybe the other I guess concerns that we're raising become less of a concern. So I guess it's that's yeah, we obviously need to make the point now at the various zones. So yeah.
Okay, well, what I'd like to offer to you is feel free to engage with council officers as we move through these other, because obviously this is a matter that applies to a number of zones and services. So perhaps encourage you to engage with council officers and see if you can't narrow down some of your concerns on understandings on these various provisions.
Sure. Yep. No, that will be helpful. Thank you. Yep.
Otherwise, thank you very much for your attendance, and your answers to our questions. And we look forward to seeing you again in another hearing soon.
You will. Thank you for the opportunity once again.
Okay. Thank you.
Thanks.
And thanks to the council. Okay. Right.
Yeah, so I've asked to bring lunch forward to 12:30. Yeah. Yeah, we could come back at 1:30. We do have an after lunch committee here who is happy to wait until 1:30.
Okay, we'll do that. We'll adjourn for 1:30.
Okay, I am stopping recording. And I'll let them know we're ready.